Okay, let's get started. Good morning, everyone, or depending where you are, good afternoon or good evening. My name is Alex Zhang. I'm a research professor of law at Duke University Law School in the United States. I'm also the outgoing co-chair of the International Legal Research Group of the American Society of International Law. It is my great pleasure to welcome you all to our webinar, which is a book launch of the highly anticipated book, Research Handbook of International Solidarity and the Law. This webinar is co-sponsored by the International Legal Research IG and the Latin American Interest Group IG. And before we actually dive into the substance of the book, I would like to introduce our moderator, who is also the editor of this book, has also contributed chapters to this book, and who is also the co-chair of the Latin American Interest Group. Professor Cecilia Bai. Professor Bai is the director of the Master Program in International Law at the Institute of Public and International University of Oslo, Norway. She's the United Nations independent expert on human rights and international solidarity. She has published extensively on transnational and cross-disciplinary issues within the field of international law, including general public international law, human rights, refugee, con law, counterterrorism, gender and women's rights, and a topic that is hugely relevant to today's book, solidarity and peace. She has also contributed lectures for the well-known United Nations Audiovisual Library of International Law, and she has authored multiple books, including the one that will be the focus of today's webinar. Now, without further ado, I would like to welcome Professor Bai to take the stage.
Thank you very much. It's a huge honor to be here to present some of the scholars of this remarkable collection of really innovative chapters in an age of polarization and decoupling. I invited people from a range of different disciplines to invite us to think about in what ways can we encourage cooperation to address the biggest global challenges that we're facing today. So we're going to start with Obi Aginam, who is a professor from UN University and contributed a very, very meaningful chapter looking at the issue of global health. So Obi, I'm going to turn to you. And of course, the COVID-19 pandemic is at the top of our mind. It was marked by the significant disparity both within and between nations in terms of access to vaccines and healthcare during health emergencies. Now, Article 2 of the revised draft declaration on international solidarity identifies reactive solidarity as collective or individual actions to respond to and to solve global challenges, including inter alia health emergencies. So your chapter argues that the realpolitik of insulating one country or region from the exotic diseases of less developed regions is anachronistic in an interdependent world. And you call for a solidarity approach to guarantee all people the right to health. Can you please elaborate on your vision, given current developments and setbacks in establishing guidelines and other instruments or institutions for global health cooperation?
Thank you very much, Professor Belliet, for this introduction and for your leadership, all through the time that this book was being prepared. I admire the way you coordinated all of us and the time and the patience, and it was also in the midst of the pandemic. We were supposed to meet in Oslo, and it didn't happen, and there was an online workshop. So I to start with the question that you posed. In terms of my vision, for global health cooperation and the argument that I made in the chapter, I want us to go back to 75 years ago. What happened in New York? When a few states, gathered to that was the formative years of the World Health Organization, and this was just 1 year after the UN was established, So, and that was at that International Health Conference that was held in July 1946. Those participating states, about 30 of them, signed the Constitution of the World Health Organization, which came into force 2 years after, in 1948. It was ratified and codified by those states. Um, so 1948 for scholars of human rights, is always an important milestone. Why? Because the Universal Declaration of Human Rights, and also when we talk about human rights, we discuss human rights developments. Most people actually don't talk about the WHO Constitution, which again, like I said, was adopted, came into force in 1948. And if you look at the preamble to the WHO Constitution, it provides that the enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being without distinction of race, religion, political belief, economic or social condition. Put this in the context, just suppose that with Article 25 of the Universal Declaration of Human Rights. So here we have two very important pillars, normative pillars, on which all the development that we have in human rights in the past 70 years, have operated from. So these are the foundational architecture, of international human rights scholarship. Now, if you go through the entire gamut of all the human rights, virtually all the human rights treaties, from the UN Convention on Rights of the Child to the Convention on the Elimination of all forms of discrimination against women, you find there's always an article on right to health, whether it's for the child or for women or for disabled people or for indigenous people. Then you look at the regional human rights instruments, the African Charter, the Inter-American Convention, the European Convention. All of these have, very strong, provisions on right to health. The further down the WHO Constitution, there are very important pillars, what I call the solidarity pillars, on right to health, and very, very ambitious for something that was actually, written in 1948. So 75 years down the line, we're now confronted with the fact that we now live in a global world, where globalized world, where people are moving, goods and services are moving from regions across societies. And that's the context in which we have to understand the pandemic. For instance, something like, COVID, appears. And then we live in North America, or you live in Europe, or you live in Latin America, and you think, oh, this is something happening in Asia. Okay. Within a couple of days or, weeks, because of this global interdependence, it emerges and becomes a global threat. So in the context of the argument I put up in the chapter, it has been argued very strongly by so many scholars of international law that yes, we have provisions of solidarity in so many international treaties and conventions, but it is not yet possible. This is a school of thought. It is not yet possible to draw a clear set of duties and obligations for international subjects, based on, these solidarity issues. So the question, therefore, is how can we, based on the context of the lessons from COVID, inequalities to access to vaccines, medical countermeasures, therapeutics, diagnostics, and all of that. How can we actually move forward, to utilize these, provisions in international human rights instruments on right to health, starting with the WHO Constitution, to achieve, solidarity in a globalized world. And I argue, I can't, because of the limited time we have, my argument was that, the way forward for solidarity to bear the much desired fruits in global health cooperation would, would focus on, be anchored on two approaches. The first is the continuous evolution and adaptation of the normative authorities of regional organizations. Of course, the EU, African Union, the Latin American region, and all of that, towards harnessing the solidarity principles in their respective constituent instruments, to address the needs of states, societies, and peoples in their respective regions. And I give examples in the chapter. So if you read the chapter, you see how I discussed that. The second approach is to focus on a massive reform of the post-COVID global health governance architecture to address the 21st century realities of these inexorable interdependencies of nations, societies, and peoples. And again, there's a lot of proposals have been made on this. One of those, which I discussed at the end of the chapter, is the policy recommendations of the independent panel on pandemic response and preparedness. There are 6 to 7 key principles, key policy recommendations. One of them being the fact they need to have a pandemic treaty, which WHO member states are currently grappling with. They have just about a week to go, to see if it will be adopted at the World Health Assembly at the end of this month. The 77th World Health Assembly, which is where all the 194 member states will be represented. So for the past 2 years, the pandemic treaty has been under negotiation. There has been a whole lot of fights. There's a group of states that call themselves the equity states, the human rights and equity states, and then there are others who are pushing back. So we see the setbacks in terms of, say, for instance, the relevance or the role of intellectual property issues, patents, which is being pushed very hard by some states. And we saw the role that it played, during the pandemic, when South Africa and India, approached the World Trade Organization and requested for a waiver of intellectual property rules, at least for the time being, until the time that the whole world is, a significant percentage of the world is vaccinated against the COVID, pandemic, or the COVID virus. So, so these are the, in terms of the way forward, those key, policy recommendations, including those made by the independent panel on pandemic preparedness and response. But there are, just as I argued towards the chapter of the book, that we have to focus more on continuous evolution and adaptation of normative authorities of regional integration organizations, and keeping a very close eye on how an instrument like the pandemic treaty, whenever it comes into force, can actually harness these foundational principles that we have in international human rights instruments on our right to health. So I think I'll stop there in the interest of time, and I will encourage participants to read the chapter, where I laid out the arguments in more detail.
Thank you very much. That's excellent. That overview, it really connects to the next speaker, because Usha is looking at the state of divisions in the world, and she starts her chapter by noting the severe economic inequality in the world that's linked to the systemic collapse of ecosystems. And so for most people, she notes, the poorer 80%, their grossly unequal access to natural resources is compounded by also bearing the brunt of the pollution generated by the rich. So Usha, you characterize climate change as one example of systemic widespread environmental injustice. The revised draft declaration on international solidarity, Article 3, describes international solidarity as creating an enabling environment for building the capacity to address, to mitigate, and to adapt to the negative impacts of climate change, including through adequate compensation for the human rights violations attendant on loss and damage, and empowering civil society organizations and civil movements. You actually call for a TWAIL solidarity approach to transform international law from being a long-standing tool for protecting the interests of the rich and powerful towards becoming a means for enabling what you call global justice. So I'm wondering if you can explain, what are the components of TWAIL solidarity in the context of the pursuit of environmental justice? And I want to point out that Usha is a professor at Yale Law School, because I forgot to mention that. So please, Usha, Nartaja.
Hi. Thank you, Cecilia. Hi, everyone. So first of all, as Obi said, Cecilia, you have guided us so thoughtfully, really shepherded us through this project. Thank you for that, through some tough times. So really appreciate that. And thank you to the ASIL Legal Research and Latin America interest groups for hosting this book launch. So And I'm speaking to you from Kingston in Jamaica. So just to say, particularly small island states in terms of facing loss and damage from climate change, it's a disproportionate impact in areas like the Caribbean, the Pacific, and other small island states in the Indian Ocean as well. So anthropogenic climate change caused by people as opposed to natural processes, is caused by, as we all know, increased greenhouse gases in the atmosphere, which come from burning fossil fuels and from the changing patterns of land use. So climate change is occurring alongside these other international environmental transformations. So this includes the biggest disruption to the Earth's nitrogen cycle in 2.5 billion years, and a mass extinction of species for the first time in 66 million years. So, and when it comes to the climate, the first time we've had this much carbon dioxide, the last time we've had this much carbon dioxide in the atmosphere was 3.5 million years ago. So we are talking about ecological change today, which is at a scale unprecedented for our species. And so who has caused this change? And this is a cause of injustice. The lifestyles of today's wealthy few are sustained not only by increasing economic inequality, but by the systemic collapse of ecosystems. We have the richest 20% of the world who consumes 80% of natural resources, and they produce 90% of all pollution and waste. And that's all consumption and all pollution, not just climate-related consumption and pollution. And so for most people, for the poorer 80%, as Cecilia mentioned, the vast majority of this poorer 80% is in the global south. Their unequal access to natural resources is compounded by also bearing this pollution generated by the rich. And disparities that are on this scale are not, a coincidence, or they are systemically produced. And climate change is the inevitable byproduct of 5 centuries of European settler colonialism, conquest, genocide, slavery, apartheid, racial discrimination, and the plunder of the labor and the resources of the non-European world to fuel European accumulation and industry, while erasing alternative development pathways. And laws and institutions, whether domestic or international or transnational, have played a central role in structuring this inequity over many centuries by insulating the rich from the rich and the powerful from the harmful consequences of their actions, and ensuring that the suffering is largely borne by others. And so there's no real incentive for the rich to change the way they do things. As we know, neither Europe nor its vast settler colonies in the Americas and elsewhere have provided any legal redress for the enduring harms of colonialism, genocide, slavery, apartheid, and plunder. And so it's against this background of institutionalized unaccountability, institutionalized irresponsibility that's increasingly described as a climate apartheid, that the issue of climate injustice has arisen in recent decades. And to overcome this type of injustice, and the solidarity is the only option. Building solidarity and cooperation amongst the poor majority who are on the front lines of environmental harm. And such solidarity can, potentially transform international law from being this long-standing tool for protecting the interests of the rich and powerful into becoming a means for enabling global justice. And in this context, I feel it is incredibly beneficial to articulate the principle of solidarity more explicitly and more fully within international law, as the independent experts have done. Currently, Cecilia, and before her predecessors, Obi and Virginia. And particularly for international lawyers, the UN Charter, as well as the Declaration on Friendly Relations, recognize that international cooperation and solidarity are the fundamental principles underlying the endeavor of international law. And for someone from the global south, I've found this to be crucial and true, because it was only through third world solidarity, through struggle and strategic and tactical alliances, that many contemporary international law principles were achieved, such as the right to self-determination for all peoples, the right to development, the doctrine of permanent sovereignty over natural resources, the common heritage of mankind, the prohibition of apartheid and racial discrimination, the principles of sustainable development, and of common but differentiated responsibilities for the global environment. And for me, as part of the TWAIL, the Third World Approaches to International Law movement, this type of solidarity is central to why I'm an international lawyer. And the TWAIL movement enters deeply into the politics of international law. Who makes these international laws? When did they make them? Why did they make them? And why did they make them then? And Twailers have identified the origins of international law 5 centuries ago as part of the project of European imperial expansion. And then we carefully trace the operations of international laws and institutions since then in imperial ventures all the way up to contemporary globalized environmental harms. And Twailers are very much committed to undermining the imperialism of international law through democratizing the discipline, through creating a genuinely international law, instead of serving as this vehicle for universalizing Eurocentric interests and values. So despite these legacies of imperialism, there is this inevitable turn to the rule of law, because it is a crucial part of environmental justice movements one way or the other, because a law creates the enabling environment for making solidarity possible. It holds out the promise of equal application, regardless of differences in wealth and power, and it's the only avenue that does that, actually. And it's an avenue for ensuring consistently just outcomes in the long term. So in this context, the turn to international law represented in this Solidarity Draft Declaration, it's about more than international cooperation. Rather, it's a demand for justice on the global scale in the same vein as these third world international law achievements that I mentioned earlier. So accordingly, the draft declaration conceives the right to solidarity as, among other things, the right of all peoples to participate meaningfully and contribute to the international order. And so for me, this was the most important aspect of the draft declaration, simply because I am an international lawyer. So in my chapter, I look at how international laws on climate change have incorporated notions of international solidarity, most formatively through the concepts of sustainable development and common but differentiated responsibilities for the global environment. And I trace the history with a view to understanding why such laws have failed, obviously, to provide climate justice. And contemporary efforts to articulate more fully a right to international solidarity are really crucial, given particularly these failures of international climate law. And for instance, we've emitted as much greenhouse gases since the Framework Convention on Climate Change as in the whole of human history before the convention. So it has been quite a spectacular failure. So alongside that has been this concomitant rise in climate justice movements all over the world. And climate justice is this extremely high stakes endeavor, because we're talking about extractive industries, some of whom are more powerful than most states, and that have been accumulating rents at these levels more than 100-fold the cost of their operations for many decades. So stemming from this greed, there has been this horrifying increase in the number and the severity of attacks and assassinations of environmental defenders worldwide, just providing a stark reminder that solidarity is the only means of overthrowing these insatiable interests to ensure a future for the vast majority of the world's population. Beyond this, environmental, one point that I make that might be worth adding is that environmental problems such as climate change do expand conventional notions of solidarity within Western thought. So, we are familiar with the French Revolution demanding solidarity between citizens and Kant envisioning solidarity amongst all humanity. But environmental change points to the existence of a deeper solidarity, that climate justice doesn't just require that people treat each other better. More fundamentally, it demands a recognition of the link between the way people treat each other and the way they treat the natural environment. After all, humans are not neatly separable from or superior to each other, and similarly, neither are we neatly separable nor superior to the natural environment. And we're intertwined within this web of existence. So the human body, the mind, the spirit is composed entirely of the air, water, food, minerals, and energy that we take in and ultimately expel, and to which we ultimately return. So given the inextricability of the human experience from the environment, it becomes unsurprising that the society that is characterized by genocide and slavery and apartheid and racism and patriarchy has also decimated the natural world, perceiving nature, including human nature, not as an underlying unity, but as competition. So just as people treat animals as slaves to the human appetite, caged to our physical and emotional and entertainment needs, and sacrifice to our scientific research, people similarly see each other as no more than service providers, whose labor is surplus or replaceable under the onslaught of globalized capitalism. So rather than treating existence as this challenge to be controlled and subdued to limitless human egotism, more sustainable ways of life perceive the well-being of others and nature as an inseparable part of individual well-being. And so solidarity in this deeper sense is not species or place-based. While we should be more attentive to each other, to the non-human world, to the environment, to the deep sea, to outer space, and so on, and important, and all of that attentiveness is an important and necessary part of solidarity. My argument is that is insufficient unless this outward journey is accompanied with a concomitant journey inward towards more fully realizing our interconnection and interdependence. So I'll stop there.
Thank you very much. Very inspiring. I'm sure the audience has many questions, and if you do have them, please put them in the Q&A box, and we will have a specific time after the presentations to address them, so you can just go directly there. So we will move on now to Vasuki Nasaya from NYU. And I think solidarity was just skyrocketed into everybody's vocabulary because of the recent ICJ case issuing provisional orders in South Africa versus Israel. And this has been characterized as an example of the role of the court as an institution of international solidarity through accountability. So in your chapter, you pursue a historical approach in which you explain how the legal standing of solidarity was one of the most important touchstones of the International Court of Justice jurisprudence, addressing questions of colonialism and anti-colonialism. In 1960, Liberia and Ethiopia, the only African countries that had been part of the League of Nations, exercised solidarity with the people of Namibia, then called German Southwest Africa, in instituting proceedings against South Africa at the ICJ relating to the interpretation and application of the mandate for Southwest Africa. You argue that the ICJ's decision in this case may be considered a mistake from the perspective of transnational solidarity. Namibia's right to self-determination and Pan-African solidarity are inextricably bound in the question of Liberia and Ethiopia's jus standi. Can you explain further this perspective? Oh, you have to put your mic on. Your mic is off, Vasuki.
Sorry. Thank you so much, Cecilia, and to my fellow panelists as well. Yeah, let me sort of jump in. And I did want to apologize in advance, actually, before I do that. I have to leave close to noon, so I may not be present for much of the Q&A. But certainly, if you put questions in the chat, perhaps I can respond while I'm here, and then I'm happy to talk to you later on. And yes, I mean, I think in a sense, we are living in a moment, I think, which has both seen a resurgence of the importance of solidarity, certainly in the International Court of Justice, and that's what I've turned to discuss, but also more generally, you know, we are just coming out of, we have a second round of arrests at an encampment at NYU this morning. And, you know, it's solidarity at the most intimate level, where you see people coming together across different historic, political, religious, and other allegiances in common cause. But certainly we see it at the ICJ as well. And while today the ICJ may offer one of the most hospitable forums for South-South solidarity, its record has not been so salutary. As Cecilia mentioned, in 1960, Liberia and Ethiopia exercised solidarity with the people of Namibia, then called German Southwest Africa, in instituting proceedings against South Africa, then apartheid South Africa, at the ICJ for violating its mandatory responsibilities to the people of Southwest Africa. In a judgment that shocked the anti-colonial world, the court ruled that Liberia and Ethiopia had no legal interest in the matter at hand, and therefore no jus standi to bring the case. In the chapter, I go through a lot of the doctrinal arguments and developments within the ICJ in that period. But today, I want to perhaps focus on some of the thematic issues that the chapter also focuses on. Because the decision of the court was doubly problematic, because the court not only perpetuated South Africa's denial of Namibian self-determination self-determination rights. In refusing to give legal recognition to solidarity as a basis for standing, the court also got it wrong on the question of internationalism. And in this way, it curtailed Liberian and Ethiopian sovereign interests to the narrowly territorial. So it was a case, I would argue, where jus standi becomes, in some sense, the proxy for a discussion about solidarity. Indeed, Namibia's right to self-determination and Pan-African solidarity are inextricably bound in the questions of Liberia and Ethiopia's jus standi. And the language of solidarity does not emerge in the submissions of Liberia and Ethiopia, but it is the core concept that is articulated in their claims, in the opinions of dissenting judges, and in the court's own jurisprudence in subsequent cases. Solidarity is central to the stakes of Pan-African and South-South solidarity in the dilemmas of post-coloniality and the limits of national independence in the context of a racial capitalist world system shaped by histories of capitalism, slavery, and colonialism. In her book, World-Making After Empire, Adam Getachew argues that self-determination struggles were not merely bilateral battles between colonizer and colonized, but collective battles to remake the world. Already independent nations with independent international legal standing and membership in the General Assembly instigated the legal corollary of that recognition in a series of cases, such as the South Africa case, requesting ICJ's advisory opinion on a series about nations that were not yet independent and therefore without formal legal personality to represent themselves. So including Palestine, the Western Sahara, South Africa, and Namibia, as we've just discussed. All these cases have been understood in terms of a collective struggle against colonialism, not merely cases of nation building, but cases of world making. Indeed, central to these interventions is the appreciation that the individual nation state cannot give life to self-determination in a world made by colonialism. Instead, when articulated through solidarity, self-determination comes to life as a collective political process. Articulating self-determination through collective action, sort of much like how Yusha has been discussing just now, was key to a formerly colonized nations confronting what the draft Declaration of Solidarity references as the asymmetries and inequalities of the international system. In this way, collective initiatives such as the NIEO were what the great Tanzanian freedom fighter Julius Nyerere described as a trade union of the poor. In this tradition, the right to solidarity is both end goal and enabling legal framework of the collective legal personality of the formerly colonized. Nation-state self-representation of their own interests in a case before the ICJ is a routine and uncontroversial performance of legal personhood. The legitimacy of states standing to represent interests that typically fall within the ambit of territorial jurisdiction is a default assumption at the ICJ and can be seen as a key dimension of the rights and freedoms of sovereign jurisdiction over a territory. In contrast, claims of standing predicated on the solidaristic representation of the self-determination interests of others, of people with no state of their own, has had this more contentious history. However, such claims to a transnationally grounded articulation of legal personhood are asserted more and more frequently, and in recent years, the legitimacy has become increasingly well established. The court has recognized that a sovereign that is not a directly injured party may still have an extraterritorial commitment to the injured, and the court's jurisprudence on standing has come to recognize this commitment as a legitimate ergo omnis partes claim. Its most recent and, of course, spectacular expression was South Africa's representation of the Palestinians of Gaza with a genocide claim against the state of Israel. The spirit of internationalism represented in this chain of commitment was a crucial legacy of Bandung, and of South Africa's articulation of the genocide claim was received in that spirit across the globe, and certainly across the global South. The Bandung spirit inheres not in the decision of the court, whatever that is going to be, but in South Africa's initiation of the action, and most crucially in the sweeping support for South Africa's actions across the global South by several states, thousands of civil society organizations, and if the marches around the world and the occupations in our universities are an indicator, tens of thousands of people. I would argue that the action at The Hague could be seen as an echo of the popular protest slogan heard on streets across the world in solidarity with the people of Gaza. In our thousands, in our millions, we are all Palestinians. This solidarity is in the spirit of the recent submissions of the ICJ by Gambia regarding the threat of genocide against the Rohingya people, and of course by South Africa about the threat of genocide against the people of Gaza. In effect, Gambia and South Africa are arguing that these threats fall within their own sovereign interests. These submissions give expression to the notion that anti-colonial sovereignty gives rise to a legitimate extraterritorial legal interest that can anchor the notion of standing, and the recognition of such interest is already sedimented into customary international law in the context of self-determination struggles. We can ground the legal status of the notion of solidarity in some 70 years of solidaristic engagement in a range of international fora to collaboratively advance the right to self-determination. We can also situate this argument in sources such as the General Assembly resolutions, the work of the international institutions on treaty obligations and third-party interests, and resolutions of multilateral organizations such as the Non-Aligned Movement. These contribute to the notion that there is a legal right to solidarity in customary international law, and that this right emerged in ways that were co-constitutive with the right to self-determination. Fittingly, the Office of the High Commissioner for Human Rights, and that's as a precursor to this book, is the catalyst for this book, by its special procedures, is working on a draft declaration on the right to solidarity, as Cecilia knows, and that explicitly recognizes that right in a human rights instrument. In doing so, this declaration is not, I would argue in conclusion, not introducing a new legal principle, but is seeking to recognize a right that has already been given expression in the state practices of the formerly colonized world. As discussed, these state practices have given expression to jurisdictional interests that were extended to solidarities, especially solidarities with people whose right to self-determination continues to be denied. Let me stop there.
Thank you very much. I think it's particularly poignant the way you draw the parallel between the ICJ cases and your very own students who are risking their own liberties to defend those who are completely deprived of voice. So, but you articulate a focus on the regional actors in Africa, and now we're going to turn to Elizabeth Salmon, who will take us to Latin America. So Latin America, according to you, has solidarity also as a founding principle. It's not just an African principle, it's also a Latin American founding principle of the OAS. And according to you, it's instrumental in addressing inequities and guaranteeing the effective exercise of human rights. Particularly, you underscore those which are economic, social, and cultural rights. However, you point out that the inter-American human rights system has actually seldom used this explicitly to address state obligations. It's instead referred almost exclusively to cooperation. But you're optimistic because you point out that there's a trend to recommend reference to global solidarity to address challenges such as migration, the COVID-19 pandemic, and corruption within the region. So the revised draft declaration on international solidarity, Article 3, sets forth that the general objectives of international solidarity are to create an enabling environment for promoting the realization and enjoyment of all human rights and fundamental freedoms. Would you please elaborate on both the normative history and the current evolutionary interpretation by the Inter-American Commission and the Court of solidarity in the context of human rights? And Elizabeth Salmon, I forgot to mention, of course, is professor at the Pontificia in Peru.
Thank you. Thank you very much for inviting me to this first public presentation of our book, edited by our friend and admired colleague, Cecilia Baye. I would like to address your question in 3 steps. In the first place, we need to acknowledge that the notion of solidarity is not absent from the Inter-American human rights system. However, it is still necessary to clarify whether and how the solidarity principle translates into concrete calls to action by the bodies composing this system. Solidarity appears in the constitutive treaty of the Organization of American States and in the preamble of various other treaties between the American states. In this sense, as it's recognized by the United Nations, the Charter of the Organization of American States is one of the various regional agreements which are founded on solidarity and express international solidarity and cooperation. Let me tell you that this is hardly surprising if we consider the role played by Latin America in the current understanding of solidarity, mainly through the contributions of the Chilean diplomat Hernán Santa Cruz as a drafter of the Universal Declaration of Human Rights. From the preamble, American solidarity or inter-American solidarity and good neighborliness refer to the consolidation of a system of individual liberty and social justice based on respect for the essential rights of man, end quote. This definition, I think, places human rights at the center of the concept. Inter-American solidarity is thus based on respect for human rights and requires representative democracy from states. Solidarity, in turn, inspires joint efforts to achieve social justice and the integral development of peoples. On the other hand, we can cite 7 inter-American treaties emphasizing the relevance of solidarity for the achievement of economic, social, and cultural rights. And this includes the duty of cooperation to fight discrimination against several groups of society, like women, persons with disabilities, older people, among others. It remains, as I say, to be seen the concrete ways in which these commitments translate into calls to action by the bodies composing the inter-American system. This leads us to my second step, which is to consider the challenges that demand a stronger response by the main bodies. It is evident that the context of the pandemic was a huge challenge demanding solidarity, and at the same time, a challenge for the implementation of solidarity in the inter-American human rights system. In Latin America, the pandemic highlighted persistent problems of inequality and lack of access to health service for the most vulnerable groups. Thus, it is useful to consider how solidarity is mentioned, for instance, by the Inter-American Commission and by the Inter-American Court as the basis of the state actions regarding the pandemic. For example, in connection with human mobility, the Commission has warned out about, quote, fear of contracting COVID-19 has exacerbated xenophobic discourses by blaming people in movement for carrying the virus and causing it to spread, end quote, which has developed into policies that affect human rights, such as the placement of armed forces at borders, the increase of immigration detention and deportation, among others. Needless to say, leaving aside COVID-19, human mobility is an issue on its own, demanding solidarity. In this respect, one special challenge, let me tell you, is to convince the states and societies to blur the difference between nationals and foreigners whenever human rights are at stake. There are some interesting examples in Latin America. For instance, local governments in Colombia have developed action plans regarding healthcare for the migrant population. In this regard, an active and permanent search program for positive cases of COVID-19 was launched in the Malcao municipality, targeting the uninsured migrant population to provide timely care and guidance, home care, to prevent the spread of the virus. Another example is the initiative of the Ministry of Health of the Autonomous City of Buenos Aires, which authorized migrant health professionals to work in public hospitals with a temporary registration. Last but not least, corruption is one of the biggest challenges that the governments of Latin America and the Caribbean region face. According to the Inter-American Commission, again, quote, on the one hand, acts of corruption may in themselves constitute human rights violations, and on the other hand, corruption in its various guises may impair enjoyment and exercise of human rights, end quote. Additionally, organized crime and drug trafficking are two issues related to corruption identified in America. To respond to this problem, the member states of the Organization of American States adopted in 1996 the Inter-American Convention Against Corruption, which aims to make every effort to prevent, detect, punish, and eradicate corruption in the performance of public functions. Furthermore, states created anti-corruption mechanisms founded on the principle of cooperation that provides a space for states parties to collectively share their best practice against corruption and get some model laws and legislative guidelines to facilitate efforts to create a national anti-corruption legal framework. In this way, the Organization of American States encourages solidarity between states parties in the fight against corruption. Having mentioned these challenging factors, we may consider as a third and final step how the incorporation of solidarity within the inter-American legal system is a work in progress. So far, you can gather from the few examples I have given that the Inter-American Commission has used term solidarity extensively. The topics in which it has been used range from the safety of journalists to migration and vaccination. It can also be said that the Inter-American Commission understands solidarity as applicable to relations between states non-actors from different countries, and between citizens from the same country. As for the Inter-American Court of Human Rights, the idea of solidarity seems to have appeared more often when addressing the topic of migrants and refugees as a group under a situation of vulnerability. However, the elaboration of the concept has occurred more recently. Already in 2003, the court addressed the juridical condition and rights of undocumented migrants and pointed out that migrants are generally in a vulnerable situation as they face the absence or difference of power compared to non-migrants, and that inequalities may be maintained by states in the laws or de facto. The court also noticed that the international community has recognized the need to adopt special measures to ensure the protection of the human rights of migrants. Well, despite this development, no explicit reference to solidarity was made throughout the advisory opinion. I quoted, Judge Cansado Trindade, the Brazilian judge, however, did mention the term in their concurring opinions. Cansado Trindade affirmed that the drama, quote, of the refugees and undocumented migrants can only be effectively dealt with amidst a spirit of true human solidarity towards the victimized, and that only the firm determination of the reconstruction of the international community on the basis of human solidarity can lead to the overcoming of all those traumas. With the commencement of the pandemic, the court recognized that the problems caused by COVID-19 needed components of regional and international cooperation implemented both in a spirit of solidarity between all the states, and that multilateralism is essential to coordinate regional efforts to contain the pandemic. To summarize these remarks, I may say that although several inter-American treaties indicate that solidarity is a founding principle of the Organization of American States, and as you said, is instrumental in addressing inequities and guaranteeing the effective exercise of human rights, the inter-American system has still as a pending task to translate it into an effective call to action. Even though the notion of solidarity is present in the inter-American human rights system, it is still rather marginal, insertion, and often appears mixed with other notions such as cooperation, the fight against poverty, or the need to affirm economic, social, and cultural rights. At any rate, I think that this indirect recognition provides a basis for interpretative development of the bodies comprising the system, and also to strengthen the normative presence of solidarity within a system that sees itself as in constant evolution and that is permanently seeking to reach new ethical horizons. Thank you. Thank you for your attention, Cecilia and colleagues.
Thank you, Elizabeth. Beautifully, beautifully presented. We open the floor for questions to be placed in the Q&A box. So please feel free to write them in, and we will select them. I don't know, Alex, would you like to pose any questions to the panelists? No? Okay, well, I have a question for all of you. Because right now we see a juxtaposition. The UNDP came out with a report discussing the phenomenon of polarization in the world. And yet Vasuki was pointing out the massive wave of engagement by youth in universities across the United States, but also here in Europe and in other areas. Is civic space for solidarity, is it shrinking or is it expanding or is it both? And when you think about your own regimes and your own issues. So I'll just go across. We can start Obi and then Usha and then Vasuki and then Elizabeth quickly. Or whoever wants to begin.
If you don't mind, I may begin, and sorry to talk and run, but that's maybe what I need, what I will have to do. And I just want to say briefly that I think it is both shrinking in terms of global governance, and where we are increasingly having a sort of unipolar world. I think the proximity of Gaza to the events, the temporal proximity on events in Ukraine, and the event on one hand, and then of course in Haiti and DRC and elsewhere, speak in some sense to the way in which global governance is increasingly centralized, or there's a new formation, perhaps, this way that cusp with an expansionist and empowered NATO that is sort of one conjunction where it seems, of course, more and more hostile to particular kinds of solidarity. You know, historically, for instance, one frame on which we had solidarity globally has been the peace movement. And one of the things that people have remarked with Ukraine was, in some sense, the crushing, and particularly perhaps in Europe, the crushing of a peace movement, or the ways in which it became difficult to be pro-peace in the context of the war in Ukraine. And so in that sense, there's a shrinking. But I would say on the civil society space, there is an expansion. And that came, Gaza perhaps is the most prominent example of that. So and I think those perhaps both of those forces have, that's part of the trail analysis, in some sense, have always been in tension, but we may be at a moment where there's a new configuration of that tension. So let me stop there.
Yeah, thank you very much. Okay, who else would like to address this question?
So I would say expanding space for solidarity, but I think that there's always a reaction to that, and that's what we're seeing. But I think that on climate, on Palestine, I feel like these movements are very smart. I feel like they've developed very intelligently over the decades, and they are quite successful. And then the pushback is, of course, immense. The better you are at it, the more the pushback that you will face, and then you have to evolve to deal with that. And they've done that in the past, and I'm pretty confident they will continue to do that. And so I do feel like the space is expanding, but then of course one has to be ready as that happens for the reaction to that. That it is an indication that these movements are working. But again, I am talking about the justice movement space rather than Vasuki talked about both the global governance space and the social movement space. But with climate, I very much focus on social movements, because the international governance on climate is just complete joke. So I'm not even going to bother talking about that. It does come down to climate justice movements and environmental justice movements, and I feel like space is expanding. Yeah.
Cecilia, if I may, very, very shortly, I agree totally with what has already been said. Maybe I just would like to add that I think that the civic space is expanding, but at the same time, I feel that the threats to the civic space are also expanding. And in Latin America, for instance, we see the increasing threats to human rights defenders, for instance, climate defenders, journalists, women, or even political parties in Venezuela, or women that fight in Cuba to find their families, their relatives. So your question is very provocative because I feel a lot of things around this topic. Is it enough to say that it is expanding, or maybe it is necessary to see how we protect the civic space to expand increasingly in the coming years? Thank you.
Thank you.
Just to add, just a bit, in response to the point that Usha made, yes, it is expanding, but each time, we see an expansion, there's always a pushback, so there's this, push and pull factor. And we see that in the context of what is happening post-COVID, for instance. I've followed very closely, the fight for, the pandemic treaty negotiations, and we see very strong, positions taken by the countries in the global south, who now call themselves the equity group, in these negotiations. I've been privileged to advise some of the African governments, on the positions they've taken, very strong positions, very, very strong positions. And they said that, they're not going to, give up on any of those. And we see now, of course, a transnational alliance between the African group and Latin America and some Asian states. So it's interesting to see how this, ends up. To the extent that, this has gone on for 2 years now, and is being concluded this week or next in Geneva. And I tell people that, what actually you find in the pandemic treaty, depends on, how all of these, power blocks are willing to give up, some of their, some of their powers, in order to have a much more, humane, global health governance architecture. So it's interesting. So it is expanding, but there's also a lot of pushback,
Thank you very much. I looked at the question box and there doesn't seem to be any questions. So I think we can probably round off this session. I'm happy to report that we have a series of events that will be presenting different chapters from the book. Usha is going to be appearing in an event we're having in Cape Town, the University of Cape Town, where Obi Okafor, who has another chapter, and Harrison Mabori, he's addressing trade solidarity. That will also be occurring at the end of this month. At NYU, Jaya Ramji Nagalis, she's an ASIL member, and she has a chapter on refugee solidarity. So that event will be happening at NYU at the end of this month as well. So we're going to be continuing this conversation about whether solidarity perspectives are expanding or being constricted, or both, and probably both. And we're going to be tracking the experiment of whether this revised draft declaration on international solidarity, which is in the chat box, whether it will be able to be pursued in intergovernmental group offense at the Human Rights Council, and we can birth a new generation of international law. I'm hoping that will happen, but it actually takes dissemination and conversations like this, where people start to discuss, what do we mean by solidarity? Is it empowering? And how can we use it in a practical manner? The topics we covered here discuss the different ranges we have, from grassroots community engagement at the political level, from actually referring to it in concrete institutions that can be judicial or can be non-judicial administrative, and at the national level and the regional level. So the wonderful thing about solidarity is its flexibility, that it is adaptable to different contexts, and it can be situated in a way that best fits the particular topical and geographic challenges and preferences that are placed before it. So I remain essentially optimistic. I guess that's why I was the editor. I believe in the project, and I'm really grateful, because of all the books that I've ever produced, this is the one that is most meaningful to me, because I was in awe of all of the authors. Every time I received a chapter, I had a very, very emotional reaction to the words I was reading, because these are people with tremendous confidence over their fields and tremendous dedication. So I really I think it was a privilege to work with all of you. I respect your work, and I'm excited to see your future publications as well. And I hope we can keep in contact with each other. For those of you online, I put the link to the book there, and it should be available in ebook within a recent period. So please feel free to email any of the authors who are here, or email me, and we'll be happy to give you more information about the materials we worked with and the topics. So thank you to Aisel and to Alex for letting us come with this book of provocative research on a new human right. I don't know if maybe you want to say a few words on behalf of your research group.
Oh, absolutely. And I have to say that I learned a lot about this topic now, and I feel very empowered. And I look forward to reading actually different chapters. And one thing I want to say is that, this is a very important topic, and we have a group of people who are specializing on foreign international research, and they're very passionate about topics like this. Sometimes it's hard to find a lot of resources if you are only looking into one jurisdiction. Even in the United States, it's hard to find a lot of resources. So when you invited us about co-sponsoring, I thought this was a great opportunity for us to even know a lot about what's happening outside the US, what type of resources, or maybe lack of resources that people can help each other. So thank you so much for inviting me. And this is a really fruitful hour for me. And now I started looking into maybe I should see how the emerging legal research resources like II could help with this type of movement in the future. So
Wonderful. So this is a conversation that will remain ongoing. So, okay, then on behalf of Alex and myself, I thank everybody who's participated, the audience and the participants most of all. It was a wonderful, wonderful conversation, and we hope you enjoy the weekend.
Thank you.
Thank
Thanks,
you.
Cecilia.
Bye.
Thanks, everyone.
Bye-bye.
Bye.